Thank you very much. The next item of business is a debate on motion 23803 in the name of Gil Patterson on the post-mortem examinations defence time limit Scotland Bill at stage 1. Can I invite members who wish to speak in this debate to press their request to speak buttons now, and I call on Gil Patterson to speak to and move the motion.
Many thanks, Presiding Officer. I am delighted to open today's debate on the general principles of the post-mortem examinations defence time limit Scotland Bill. This bill has been a long time in the making. I began this quite some time ago in 2016. This followed a meeting with my constituent, Pamela Monroe, whose 15-year-old daughter, Paige, was murdered on the 19th of March 2016. Despite a suspect being charged within a week of Paige's death, a defence post-mortem examination wasn't held until the 15th of April, and her body was released to her family on the 18th of April, 30 days after her murder. There was no transparency in the procedure, and this caused a great deal of distress to her family, who lost the chance to properly say goodbye to Paige. The anguish and pain experienced by Paige's family is thankfully unimaginable to most of us. However, it is my belief that there is no reason any family should have to live with such uncertainty as to when the body of their loved one will be released following a murder. Even one such incident, in my view, is totally unacceptable. My bill therefore proposes simple measures which can increase transparency in the system, help families to better understand what is happening, and ultimately, I hope, lead to the bodies of the deceased being released faster. When a person dies in suspicious circumstances, a post-mortem examination is carried out by the Crown Office, usually within a few days of the death. There is also scope for a further post-mortem examination known as a defence post-mortem examination to be carried out on behalf of the accused. There is no time limit in which this must take place or be instructed. My bill will rectify this by introducing an extendable 14-day time limit in which a defence post-mortem examination may be instructed. The time limit will begin from the day on which the defence team is in receipt of the result of the Crown post-mortem examination. If the defence team need longer than 14 days to decide whether a further PME is needed, then they can apply to the court for an extension, and they can do so more than once. That protects the accused person's right to a fair trial. They need to keep applying and giving reasons for the delay. Each time should act as a spur to action, reducing the likelihood of long delays. Members will be aware that due to time constraints, the Justice Committee was unable to reach a view on whether it supports the general principles of the bill. Its response to the committee's report, the Scottish Government also did not reach a definitive view. However, since the Stage 1 report was published, both the Cabinet Secretary for Justice and the Lord Advocate have raised some concerns about the bill. Unfortunately, these seem to be based largely on misunderstandings about what the bill is trying to do and how it would actually work. For example, the Lord Advocate and the Cabinet Secretary have both suggested that the 14-day limit time in the bill would be insufficient, as it takes about the same length of time to make available the initial findings from the Crown Office PME. My intention was always that the 14-day time limit would begin only after the initial findings of the post-mortem examination were made available to the defence, allowing them full 14 clear days to make an informed decision. I believe that is exactly what the bill achieves, but if there are any doubts on that score, I am open to amend the bill at stage 2 to put the matter beyond doubt. I acknowledge that the Crown Office has already put a protocol in place which seeks to minimise delays and improve information sharing. I am supportive of the protocol and am on record of welcoming its introduction. However, a protocol is not binding, and a change of leadership or approach may mean that it is not observed in the long term. I consider that rules around timescales of defence PMEs must be put in statute to ensure that they will adhere to the long term. It is unfortunate there is a dearth of forensic pathologists in Scotland, and that this leads to delays in defence PMEs being carried out. I do not deny that this is a major problem and one which needs to be addressed. However, I don't see how this could be achieved through legislation. Any work to increase the number of forensic pathologists could complement my bill, but should not be a substitute for it. As mentioned, my bill has not been subject to the full scrutiny that we would come to expect at stage 1 in Parliament. However, this is not a reason to reject the bill at stage 1. There is still scope to further scrutiny to be undertaken at stage 2. I therefore urge members to look at the merits of the bill and what it is trying to achieve and give it the benefit of the doubt at this decision time tonight. Presiding Officer, I'd like to thank everyone who has supported the bill thus far, and I move the motion in my name. Many thanks.
Thank you very much, Mr. Patterson, and I now call on Adam Tompkins on behalf of the Justice Committee.
Thank you, Presiding Officer. This is the second of 2 members' bills that have come to the Chamber this month after having been examined by the Justice Committee. As I explained in last week's debate on Claire Baker's culpable homicide bill, the Justice Committee has been unable to devote to these bills, to these 2 members' bills, the full and detailed consideration that frankly they deserve. In part, this is due, of course, to the pandemic and its impact on parliamentary business. But in greater part, it is due to the quantity of government legislation that has somewhat deluged the committee and which we are currently wading through. As such, Presiding Officer, the committee treated Mr. Patterson's bill in the same way that we treated Ms. Baker's bill debated last week. That's to say, we took evidence from the member in charge of the bill and we published a short report inviting the government to respond in advance of today's stage 1 debate. So accordingly, we took evidence from Mr. Patterson in September, we published our report in November, and the government's response was received in January. I thank both Mr. Patterson and the Cabinet Secretary for their cooperation and for their understanding as to the constrained circumstances under which the Justice Committee is having to operate just now. The evidence we took and the views submitted to Mr. Patterson's consultation raised 3 matters which I should draw to the attention of the Chamber. First, it has to be said that the problem which Mr. Patterson's bill seeks to solve does not appear to arise very often, despite the fact that Mr. Patterson told us that the problem was fairly common. The most recent year for which statistics are available suggests that only 2 post-mortem examinations were requested by the defence, just 2 in an entire year. Now, that does not lessen the very real anguish that a family may have to endure in any particular case, where the body of the deceased cannot be released, but it does suggest that the number of occasions when the problem arises is very small. Second, submissions from the Faculty of Advocates and others suggest that when there is a problem, it's caused by a shortage of available forensic pathologists. And if this is the problem, then legislating for a maximum period of time within which the defence can request a post-mortem examination, as this bill does, is not going to solve it. And thirdly, the committee's attention was drawn to a protocol published by the Crown Office in 2018 that, as Mr. Patterson acknowledged to us, has been helpful in addressing the issues. And to this point, I would highlight the view of the Law Society of Scotland, who said that a reasonable amount of time should be allowed to ascertain how the protocol is working in practice before the Parliament legislates on the matter. Presiding Officer, in the light of these considerations, the Justice Committee came to the following conclusions. First, that it is important that the body of a deceased relative is released to the grieving family in a timely fashion, keeping delays to a minimum. Second, that the numbers of times when this fails to occur are few and far between, albeit that nonetheless each delay will cause considerable pain and distress to the family involved. And finally, that while the committee had some sympathy with the policy intentions underpinning the bill, we noted a range of issues that have been raised with the member in charge of the bill and which I have outlined to the Chamber in my remarks this afternoon. Taking all of this into account, Presiding Officer, the Justice Committee was unable to make a recommendation to the Parliament on the general principles of the bill, and so I will leave it there. Thank you.
Thank you very much. And I now call on Hamza Yousaf to open on behalf of the Scottish Government. Cabinet Secretary.
Presiding Officer, I want to begin by first and foremost paying tribute to Gil Paterson, his dedication to this issue for several years now, and for his hard work in bringing this bill before us. I know he has been engaging with successive Justice Secretaries, with the many interested parties, of course with families and victims, and with the Parliament's non-government bills unit to get to this very point. It is right to acknowledge at the beginning the importance and sensitivity of the issue the bill addresses. The experiences of the family of Paige Docherty, which he has so clearly set out, are unimaginably awful. I can only again express my condolences to her family and of course all of the families that have been affected. Paige's case is not the only one of this kind about which we've heard in Parliament. In the past, some families have experienced the distress of losing a loved one in appalling circumstances that have been made worse by having to wait for the body to be released. They were right to expect that something should have been done to stop this from happening. And something has been done, as has been acknowledged by Gil Paterson and then reiterated by the convener of the Justice Committee that we've just heard from just now. In consultation with the Faculty of Advocates, with the Law Society of Scotland, and with forensic pathologists, the Crown Office agreed and published its Forensic Pathologist Consultation Protocol. The protocol gives defence agents increased confidence in the initial examination, therefore avoiding multiple post-mortem examinations, but crucially without compromising the integrity of the justice process. The protocol has been extremely successful. Gil Paterson indicates that between December 2018 and December 2019, only 2 defence post-mortems were requested. The Crown Office's most recent information to me is that there have been not a single defence post-mortem since July 2019. In almost 100 homicide cases reported, there has not been a single defence post-mortem. As the bill consultation concluded in early April 2019, the success of the protocol, which was published in October 2018, could not, of course, in fairness, become apparent. Circumstances have moved on, the issue has progressed. Then the bill was introduced in a period of unprecedented difficulty, and scrutiny was never going to be straightforward, again, as the convener of the Justice Committee has just reflected upon. The committee was unable to make a recommendation, and somewhat unusually turned to the government for a view. Given the inability of the committee to scrutinise the bill fully, or indeed make a recommendation, the lack of oral evidence taken, and my concern that the bill would inadvertently, of course, make the situation worse for victims, I cannot in good conscience support it progressing to stage 2. I know that will be of great disappointment to Gil Paterson, but I hope he and everybody will understand that all of us have only the victims and their families very much at the forefront of our minds. I did not benefit from evidence from interested parties that would usually form a key part of stage 1 scrutiny of the bill. Although, as I say, the bill is undoubtedly well-intentioned, I think it is unlikely to lead to fewer or quicker defence postmortems. In fact, of course, it is difficult to achieve fewer than no postmortems at all, as is the current case with defence postmortems. Conversely, my concern is, Presiding Officer, that by requiring defence agents to, well, effectively put up or shut up, as it were, it is very likely to encourage them to put up. The bill is likely to compel defence agents to meet the requirements of their professional responsibilities by instructing their own examination. Indeed, the timetable allows them little other choice. There's a real risk the bill would thus lead to more defence post-mortems rather than fewer. I'm also concerned about the possible implications of requirements to make applications to the court. This may require disclosure of the details of investigations which are being undertaken, and in some cases even the next of kin may also be the accused or indeed under suspicion. Regarding the 14-day time limit is the issue that gives me the most concern. The bill states that this would run from the notification of the cause of death, something that Mr Patterson has reiterated. However, the mere cause of death tells defence agents very little. Only with the production of the draft full post-mortem report can they make an informed decision on whether to require their own examination. The Crown has indicated that the production of this draft takes on average 14 days, leaving no time to make a decision. There are further drafting problems, but the overriding consideration is that any imposition of a time limit, whether that's 14 days or indeed even if that was changed to be a longer time limit, is much more likely to do harm, I believe, than do any good. Thanks to the success of the protocol, we are in the enviable position on post-mortems. I would ask Parliament to recognise the significant progress that has been made with the development of the protocol. In addition, given the lack of scrutiny of this bill at stage 1 and the policy concerns the Scottish Government has, we simply cannot support this bill progressing to stage 2. Presiding Officer.
Thank you very much, Cabinet Secretary. Members will be aware that we're running significantly behind time as a result of technical difficulties earlier this afternoon, and therefore, before I call the remaining opening speakers, I would like to call on the Minister for Parliamentary Business to move a motion without notice to delay decision time to 5:45. Can I call on Graham Day?
Deputy President.
Thank you. I think Mr Day has moved that motion. Thank you very much. Is that agreed? That is agreed. Thank you very much. I now call on Liam Kerr to speak in the debate. Mr Kerr.
Thank you, Presiding Officer. The Scottish Conservatives will vote against the bill at decision time tonight. Let me make clear, this is a finely balanced decision because we have a great deal of sympathy for what the member to achieve. And it's a case that I think he argued clearly in his letter of the 22nd of January, to which I'll return later. The member's bill seeks to establish a 14-day time limit on the defence requesting a second post-mortem examination, the rationale being to reduce delays in releasing bodies to grieving families. And that will reduce the grief felt by families and give increased certainty about the timing of the process and when funeral arrangements can be made, protecting victims' families from further trauma. That has to be the right way to go. And I can say that with authority, since, as we set out last autumn, this precise change will form a key part of our proposal for a victims' law that we intend to bring forward early in the next Parliament. But we cannot move this on to stage 2 today. Firstly, I'm deeply uncomfortable with the current legislative timetable in the justice portfolio and its impact on our ability to scrutinise proposed legislation. We consider this bill in a context where the convener described the committee as being awash and deluged with legislation, and with a Scottish Government which has declined to reduce the legislative workload on the committee. Now, this morning, just to give an example, the Justice Committee debated amendments to the Defamation Bill. Tomorrow is the deadline for lodging amendments to the most controversial bill in Scottish Parliament history. The daily list, I think, shows there are already over 100 amendments proposed. On Thursday, we debate stage 1 of the Domestic Abuse Bill and then look at amendments for that. Now, Presiding Officer, the Parliament must pass robust, scrutinised and enforceable legislation. Yet the member concedes in his letter of 22nd of January that no substantial evidence on the bill has yet been taken. Now, that's because, as he acknowledges, the Justice Committee was, quote, unable to take evidence prior to issuing its report. A report in which it was unable to reach a conclusion because of its inability to undertake scrutiny of a bill which the member accepts is not without its flaws as drafted, even if he's right about, for example, the Crown Office response although I prefer the Cabinet Secretary's submissions just given in this regard, and the convener's remarks on some serious challenges that we reviewed at committee are well made. Now, the member suggests in his letter that a full suite of evidence could be taken at stage 2, but I just don't see how that is possible alongside making the appropriate amendments to address the many concerns the written submissions have already raised. Presiding Officer, I therefore believe it would be irresponsible to move this to stage 2 given the time frame we have. And I further feel that the families who've been let down perhaps by the current post-mortem process would be given a false hope. But I do think it is important to provide reassurance to those families today. All too often, victims are an afterthought in our current justice system, with the SNP failing to deliver on my demands for Michelle's Law and the Victim Notification Scheme, for example. So I commit here and now that if I'm in a position to do it after the election, I will bring forward that Victims' Law, which includes the change the member seeks, so it can be interrogated, scrutinised, amended and implemented. And I will work collaboratively on that, including using the work the member's done already. And I ask the Cabinet Secretary in closing today to make a similarly firm commitment that regardless of who finds themselves in government, he will promise to work with the Scottish Conservatives to implement this measure after the election. In summary then, the Scottish Conservatives have the greatest of sympathy with the victims and the families, but to ensure that this bill works for victims, there needs to be more time to make sure it delivers, and that is time the Justice Committee and Parliament simply does not have. However, I look forward to implementing these proposals in the future. Thank you, Presiding Officer.
You are now call on Rhoda Grant.
Thank you, Presiding Officer. And can I start by congratulating Gil Patterson on bringing forward this bill. Not easy to bring forward a member's bill, so this is a success and to this stage. The bill tries to address the delays faced by families whose loved ones have been murdered, tries to speed up the time it takes to allow their body to be released for burial. This time spent waiting is heartbreaking for families. And if we are able to make this terrible situation easier, then I believe we should try. There are concerns about the bill, and those have already been highlighted. Does it actually do what it intends to do? Will it bring earlier closure to families? And the truth is we don't know. This bill has not been properly scrutinised to enable us to take a view on those issues. But what we do know is that its aims are to make things better for families. It seeks to limit the length of time during which the defence in a criminal case can request a second post-mortem. The aim is to ensure that victims' bodies can be returned to their families as quickly as possible without hindering the criminal justice process. The Scottish Government and the Crown Office have highlighted a number of issues regarding the bill. They say that the 14 days time limit is not workable. However, Gil Patterson has made it clear that that time frame can be extended and indeed does not start until the defence have received a copy of the Crown post-mortem. This tries to speed up the process, whereby trying to make this easier for families. However, these provisions do require to be examined, and it's unfortunate that this did not happen in committee prior to the stage 1 debate. And this scrutiny needs to happen before the bill can proceed. And if it needs amendment to make it workable, this can be done at stage 2. Other concerns are with regard to the unintended consequences of the bill that could undermine its policy intention. Again, that needs to be examined and amended if possible. We are told that at present there's a lack of forensic pathologists in Scotland able and willing to carry out post-mortems, and this is the main cause for the long delays experienced by grieving families. We're told that the bill does little to address this core issue, and should the bill lead to an increase in second post-mortems, that could in fact result in longer waits. But it's unclear to me why the bill should lead to more post-mortems to be carried out. But again, this hasn't been properly examined at stage 1. The Justice Secretary concluded that without full consideration of these issues, the Scottish Government was unable to take a final position and indeed will not vote for this bill tonight. However, I find it unacceptable that we vote down this bill tonight simply because there has not been enough time for scrutiny. That's not to say we don't need scrutiny, we do, but this would have to be carried out prior to stage 2. And if there's not time to do that scrutiny during stage 2, then the bill would run out of time and fall. Surely we owe it to families to leave the bill open to proceed if there is time. If we cannot make it workable, then we can vote it down at stage 3. And therefore, if we support the bill tonight, we do not give it a final approval until it has been amended, until it has been scrutinised, and therefore I would urge colleagues to vote for this bill tonight.
Thank you very much. And I now call on Liam MacArthur.
Thank you very much, Presiding Officer. This is the third of 3 members' bills debates that I've covered recently following our consideration last week, bills from Daniel Johnson and Claire Baker. Again, I think it's fitting to acknowledge the tremendous amount of work put in by Gil Patterson and the team around him, as well as his passion to see changes made that might improve the lives of those affected by delays in carrying out post-mortems. While Scottish Liberal Democrats will not be able to lend our support to this bill, the underlying motivation behind it is one we certainly applaud. At its heart is a desire to address legitimate concern about the anguish caused to individuals and families as a result of delays in our justice system. Whatever the explanation for those delays, however reasonable or justified they may be, that does not necessarily diminish the impact they have on those affected. Mr Patterson's intention to reduce the pain and distress experienced by loved ones in the midst of an already traumatic time for them is highly commendable. The pain and heartbreak of losing a loved one is difficult enough to bear and hard to process, but losing a loved one in what are considered suspicious circumstances only compounds that. When everything else seems difficult to understand, many find comfort in a process. Often families bind themselves to the routine of a funeral and burial that allows also for the natural process of grieving to take place. At the same time, however, justice also requires due process. Piecing together what happened is often the only way of providing families with any clarity as well as closure. That said, any delays to post-mortems have to be minimised as far as possible. They're not fair to anyone involved and they're in no one's interest. I'm therefore glad to see that things do appear to have moved on since the awful death of Paige Doherty, which did so much to inspire Gil Patterson's commitment to this issue. The Forensic Pathologist Consultation Protocol for Postmortems appears to have added important boundaries to the circumstances where defence agents can request postmortems. On the face of it, this seems to have helped increasing the confidence in postmortems at first instance and reducing the need for defence agents to intervene. Cases of a second postmortem, as we've already heard, being sought now look to be extremely rare. For that, Gil Patterson deserves both credit and thanks. I appreciate that Mr Patterson will be disappointed if this bill does not proceed to stage 2, as appears likely. However, I hope he can draw some satisfaction from knowing that he has helped create the impetus for changes that can and will make a difference. Thank you very much, Deputy Presiding Officer.
Thank you very much. And I now call on John Finney.
Thank you very much indeed, Presiding Officer. At decision time tonight, the Scottish Green Party will be supporting the general principles of the bill. That's what we're voting on. We'll be supporting the general principles of the bill. Now, the bill may not be the finished article, but I think we've heard from Mr Patterson. He's more than happy to engage in clarifying and other matters. Now, this is about access to a post-mortem and the defence having access rather than relying exclusively on the one provided by the Crown Office Procurator Fiscal Service. And crucially, it's about time factor. And, we're told by the Crown Office that 14 days before they could send a PM to the defence, on average. Could that be improved? Well, of course, there's issues around the number of forensic pathologists. There's issues about conflict. We heard about the protocol, and I think Mr Patterson is to be commended for his work has driven that. But that's not the finished article. We heard from the Cabinet Secretary, I hope I quote him correctly, thanks to the success of the protocol. Well, first and foremost, that's what it is. It's not a legislative requirement. And I would take issue with the Cabinet Secretary talking about the proposal that Mr Patterson has, giving little choice to defence agents rather than to go ahead. our legal system is full of time restraints, time requirements, and I have to say I think more of defence agents than that. And as for the example of, an accused may be a member of the family of the deceased, that's a situation that we must deal with at the moment. And the idea that somehow this bill introduces some merit, has no merit because of issues about disclosure of that, seems to me to be entirely fanciful. Presiding Officer, I take my approach to things in a rights-based approach, and when Mr Patterson approached me, and I should declare I'm a signatory of this bill, when he approached me, my initial concern was I didn't want anything that would denude the opportunity for the defence to have full access to all the evidence that could be exculpatory, and I'm entirely satisfied that that's the case. Mr Patterson, in his letter to the committee, told us there is no other jurisdiction that has this open-ended approach. Now, the issue of the shortage of pathologists is a matter that should be being dealt with. Of course, we know that there are shortages of professionals in various fields. The issue of conflict of interest that gives rise to. Now, some members have alluded to the Law Society's evidence, and I thought their comments about video evidence and best evidence, a legal term, best evidence, is very good. But I want to talk in the very brief time I've left about parliamentary scrutiny. It's entirely back to front in this instance. The last person we should see, not the first person, is the proposer of the bill, and we should hear from the member after we've heard and addressed the concerns. I know full well the work that's gone into this, and I don't doubt that there are some genuine concerns. It is a worthwhile proposal. It causes detriment to no one. It's about enhanced practice, and it should not fall because of the administrative processes of scrutiny, or in this instance, the lack thereof. Others have alluded to the situation with Claire Baker's homicide bill last week. Another bill that sought to directly address very widespread public concerns. I agree with Mr Patterson that agreeing the general principles of this bill does not imply that it should be passed at stage 3. Rather, it confirms it's a good idea worthy of further examination, but there may not be time or capacity to do that. Does not suddenly negate its merits. It's the merits of the proposals, not our procedures, that we are adjudicating on at decision time. It's a sound proposal, and I would urge members to support it at decision time tonight. Thank you, President Officer.
Thank you very much. We now move to open debate speeches. 3 minutes, please, for open debate speakers. Kenneth Gibson, to be followed by James Kelly.
Thank you very much, Presiding Officer, and I thank my colleague Gil Patterson for bringing forward this bill and for his hard work and tenacity on behalf of victims and their families over many, many years. This bill is sympathetic and understanding of the grief and anguish felt by those who've lost a loved one, often in the most appalling of circumstances, and the desire to reduce delays or difficulties in allowing grieving victims' families to hold a funeral following the release of the body. However, there is no evidence to suggest that delays in the return of bodies are caused by inappropriate action or inaction on the part of defence agents. Since October 2018, there has been a non-legislative forensic pathologist consultant in place to give defence agents greater confidence in the initial post-mortem conclusions and avoid multiple post-mortem examinations without compromising justice. And a year after the protocol was passed, as we've already heard, only 2 defence post-mortems were requested, with none since July 2019, and this shows the protocol is working. The Law Society of Scotland suggested that evaluating the protocol's success or otherwise should be undertaken to establish if there is any absence of due diligence in relation to its application with the defence and if further measures are needed. In its current form, the bill could create more defence post-mortems, though, rather than fewer. If applications are based on an arbitrary timescale, this could have the opposite effect to the bill's intentions and inadvertently exacerbate the stress and pain experienced by families. A defence with only 14 days to request a post-mortem before losing its right to do so is much more likely to request one. An increase in applications, which the Law Society says is inevitable, would burden courts with both the time and associated costs needed to support such a process, while an increase in applications resulting in more post-mortems, it's reasonable to assume would also be felt by forensic pathologists, of which we've already heard there's a shortage. Further scrutiny both of the bill and protocol is required to investigate how best to improve this bill and ensure it has no unintended consequences. COVID-19 and the measures it necessitates continues to impact the workings of this Parliament and the Justice Committee indicated in their Stage 1 report that they were unable to provide the necessary level of scrutiny as lockdown restrictions delayed the committee's hectic work programme. Indeed, it feels like déjà vu, given only 5 days ago we were in exactly the same position with Claire Baker's culpable homicide bill. Presiding Officer, one wonders why bills are being brought forward to Stage 1 without effective scrutiny, leading undoubtedly to disappointment both for the member concerned and those supporting a bill's aims. We must deliberate consistently and without fear or favour. This bill comes from a place of humanity and a strong desire to help families enduring unimaginable grief. Yet without appropriate scrutiny, we are at risk of passing legislation which is incomplete, possibly with unintended and unforeseen consequences. It is therefore with great regret that I cannot support this bill today.
Very much. I call James Kelly, to be followed by Rona Mackay.
Thank you very much, Deputy Presiding Officer. Can I start off by paying tribute to Gil Patterson for the amount of work he's put in to bringing this bill forward, pursuing an issue that he's raised consistently in Parliament. The objective of the legislation is to seek to provide an appropriate time limit for which the defence agents can request a post-mortem. And I think Mr Patterson highlights a very important issue, because there's no doubt that if people lose their loved one in very difficult circumstances, it's stressful enough without the body not being returned to the family after an appropriate time in order that you can have proper closure and bury the person with dignity. I felt that in quoting the recent statistics around the number of postmortems that have been requested, Adam Tompkins and Hamza Yusuf don't disagree with the statistics, but I felt they tried to minimise something that is quite a significant issue for people that have been affected by this. And Mr Patterson himself, gave his own example in terms of the constituent. The government reservations around this have been recorded in the letter to the Justice Committee. Fundamental to this has been the issue around the 14-day time limit proposed in Mr Patterson's legislation. I think Mr Patterson has dealt with that well in his response to the committee and to all MSPs. He's shown that he's prepared to have an element of flexibility around that, and I think that could be explored further. The other point I would make around evidence and timetable is a point I made in last week's debate for Claire Baker's culpable homicide bill. There continues to be a question mark over the day of the election, and while that continues, I think we should allow this bill to pass at Stage 1, take the general principles forward, because there may be some additional time that will come into being if the election is delayed. Summing up, I think the point we have to bear in mind is that the process of a bill moves through different stages, and that allows the issues to be raised. It allows changes to be made, allows more evidence to be heard, even at Stage 2, and therefore the issues that have been identified with this bill could still be addressed further down the line, and it could therefore be fixed to be a proper and appropriate piece of legislation. And with that in mind, I would certainly urge colleagues to support the bill passing Stage 1 at decision time.
Thank you very much. I now call on Rona Mackay, who will be the last debate speaker.
Thank you, Presiding Officer. It's customary to start a speech by saying how pleased you are to be taking part. Unfortunately, that's not the case for me today. To say that the Post-Mortem Examinations Defence Time Limit Scotland Bill, brought forward by my friend and colleague Gil Patterson, is well-intentioned is an understatement. I know how passionate Gil feels about this bill, which he's been working on throughout the session, and I know how hard he's been working on it. So it pains me to say that I will not be able to support the passing of the bill at Stage 1 today. As you heard in Gil's opening speech, he was moved to help the family of his constituent Paige Docherty, who was brutally murdered. The family's experience of the post-mortem judicial process was one that no family should have to go through, and Gill vowed to do what he could to lessen the pain of any family in the future who may have to face a similar tragedy. Presiding Officer, the Cabinet Secretary has highlighted the reasons why he and the Lord Advocate cannot support the bill today. The Law Society and others have also raised concerns. Alongside the technical reasons cited as a member of the Justice Committee, I know and we've heard that there was no time through no fault of Gill Patterson to scrutinise the bill or to take evidence from stakeholders or the judiciary. In its Stage 1 report, the Justice Committee noted that its ability to scrutinise the bill in depth was constrained by the current pandemic and also by the sheer volume of other business that the committee was dealing with. As a result, the committee made no recommendations to the Scottish Parliament on the general principles of the bill. Crucially, the Cabinet Secretary has confirmed, and we've been heard speakers talk about the new protocol on post-mortems, which is being successfully followed. As a result of this, no delays have happened since July 2019. I believe the heightened awareness and publicity Gill Patterson has shown on this issue at every opportunity is largely responsible for effecting this change. I know that statement will be of little comfort to Gill if his bill doesn't pass at decision time today, but I believe that his campaigning on this issue has already made a hugely positive impact on the process, and he should be commended for this, as Liam MacArthur and others have said. Without Gill's caring efforts to help the family of Paige Docherty, this process may never have been reviewed and many more grieving relatives may have faced this trauma. So in conclusion, Presiding Officer, I say again, it's with great sadness that I will be unable to vote to pass the bill at decision time today. Thank you.
Thank you very much. We now move to closing speeches, and I call on Rhoda Grant.
Thank you, Presiding Officer. This has been a short debate, but a debate in which I believe Gill Patterson has highlighted the heartache that delay in releasing a body of a loved one can cause to a family. Paige Docherty's family's plight has moved him to bring forward this legislation, and it shows, if anything, how a constituent's lived experience can influence what happens here in the Parliament, and I commend him for doing that. Speakers suggested it was a small number of people involved, and that may be right, but it's a very difficult point in someone's life, and it can have a lasting impact on their life going forward. We need to make legislation that works not only for the majority of people, but also for a minority of people, no matter how small. Gill Patterson has made it clear that the issues with regard to the 14 days cut-off is not an issue. This is 14 days from the date that the state post-mortem is being received by the defence team. And there is a chance for them, there is the ability for them to extend that again. They have 14 days to decide whether or not they need a second post-mortem, and then they can apply for an extension to allow them to do that. Now, many speakers have welcomed the protocol that has been put in place as a result of Gill Patterson's bill. But the Cabinet Secretary and Kenny Gibson have told us that the protocol is working. And James Kelly was right when he said this should not minimise the heartache faced by families. We need to make sure that the protocol not only works now but continues to do so. And this legislation could have provided the opportunity to enshrine that in legislation, and the bill could have been amended to do that. John Finney talked about the lack of pathologists, and this is an issue that will cause delay, not only for people in the circumstances that Gill is trying to help, but in all other circumstances that require post-mortem. So I would like to ask, what are the government doing to ensure that there are adequate numbers of pathologists trained, that they will be available to carry out those difficult tasks? And it would be very good in summing up if he would let us know what the Scottish Government are actually doing to deal with this issue. Presiding Officer, it takes time to bring forward a bill. Adam Tompkinson explained the difficulty that the committee faced with government legislation and the time that takes, as well as members' bills to consider. And it's not the Justice Committee's fault that there is not time. But surely this is not a good way to treat members' bills. When government bills continue to pass through the Parliament without any delay, members' bills are being lost at a very early stage. Kenny Gibson seemed to be blaming the members themselves for that. But we all know how difficult it is to bring forward a member's bill, and I'm glad that Rona Mackay made it very clear that it is not the members' fault in any case that their bill is not properly scrutinised. As I said last week with regards to Claire Baker's bill, passing the bill tonight does not mean it will pass at stage 3. But as James Kelly said, if the election is delayed, there will be ample time to carry out the scrutiny that is required to amend this bill and make it right. And if there is no time to carry out that scrutiny, then the bill will fall. So we lose nothing by letting it proceed tonight in the hope that we will have time to amend it and make a difference to people's lives.
Thank you very much. And I now call on Gordon Lyndhurst.
Thank you, Deputy Presiding Officer. Justice should be paramount in any criminal justice system and have two aims: protection of the innocent, including victims of crime, and conviction of the guilty. Part of protecting the innocent is to minimise trauma caused to the innocent, such as on the death of a loved one. This bill has commendable intentions and is well worthy of consideration. I recall very clearly the conversation I had with Gil Patterson towards the beginning of this parliamentary session, in which he set out to me his purpose in bringing the matter before Parliament, and I have no doubt of his sincere intentions in doing so. As has been said, a number of issues about the draft bill before us have rightly been pointed out as needing attention. Rightly because, more so than headline politics, law is a matter of detail which directly affects the individual, particularly in traumatic circumstances. And it is also key to a fair justice system that the accused individual and his counsel should have fair opportunity to a full and proper defence against charges brought by the Crown. Evidence from the Faculty of Advocates reflected what appears to be a systemic lack of forensic pathologists available and willing to carry out examinations and prepare reports over many years. And this is an area which the Scottish Government is responsible for. The law can say what it likes, but in spite of that, be ineffective without proper training, organising and resourcing of the various roles found in a properly functioning criminal justice system. Realities on the ground need to be observed when it comes to legislation. In the case of homicide particularly, and this is a view shared across the justice system and several of its professional bodies, examinations can be complex, with bringing of charges taking a great amount of time. A 2-week limit on requests for a second post-mortem may be too short for an informed position to be reached. The Scottish Conservatives have called for reasonable limits, however, as part of our victims' law proposals to improve the victim's situation through criminal justice reform. So in conclusion, this bill seeks to deal with one of the many issues which require to be addressed, hopefully sooner rather than later, and it is unfortunate that it cannot be dealt with in this Parliament. Thank you.
Thank you very much. I now call on Hamza Yousaf, Cabinet Secretary.
Presiding Officer, I would like to thank all of those who have contributed to the debate today, and once again pay tribute to the hard work, as everybody else has done, that Gil Patterson has taken forward in relation to this bill. As I've said at the outset, this is an important and sensitive matter. We've been able to demonstrate again the importance all of the Parliament attach to sparing victims in these extremely disturbing cases any unnecessary distress. I want to address some of the issues that have been raised, Presiding Officer, by members across the Chamber. I think it was John Finney who said that progressing this bill would have no detriment whatsoever. I would be keen to explore that issue perhaps after this debate with John Finney in greater detail, because the crux of the matter, as I have articulated in my opening speech, is that our concern from the government, and clearly the concern of the Crown in their letter to the Justice Committee, was that this bill has the potential of making the situation worse. Of course, unintentionally, but making the situation worse ultimately for victims due to the 14-day time limit. And other members have said, and Mr Patterson has reiterated, that that 14-day time limit is of course extendable. It can be extended many times. But that of course doesn't address the issue. If it is extended, of course, and the body, there is a delay in releasing the body, that will only compound the trauma for victims as opposed to address the very issue. A number of members have also talked about the protocol, and let me reiterate again, it is my very strong belief that the protocol is and has been successful. But I know also that the Law Society, in their briefing sent to MSPs, mentioned that they believe that there should be more time to explore whether or not the protocol is successful, is working, before coming forward to legislate as a parliament. I hope it is some kind of consolation to the victims whose experiences we are discussing that there has been not a single defence post-mortem since July 2019. I know that may be of cold comfort because of it won't impact the cases, their cases, but I do hope that it is some sort of consolation that this new defence protocol, it does seem to be working. The issue of scrutiny, I think, is important. I know a number of members have said that they believe that further scrutiny can take place at stage 2. I think we've heard pretty robustly from the convener of the Justice Committee that they are struggling with time because of government bills, and I accept that there is a lot of government business, important and vital government business, being taken forward by the Justice Committee. So we are, of course, also very obviously in the midst of a global pandemic, and it would be, I think, churlish not to recognise the impact of the pandemic on our collective legislative timetable. The government's position remains that there are significant fundamental policy problems. The most concerning of those in the bill is the time frame, the 14-day limit. I won't go into detail because I know I only have a little bit of time, Presiding Officer, to conclude my remarks. But at very best, the 14-day time limit will, I think, force defence agents to speculatively make a request for a post-mortem. At very best, that will create scheduling problems for premises and pathologists alike. But at very worst, of course, if an examination goes ahead, it may delay the release of a body, and all because of an artificial statutory deadline that exists. Some people have said there may be a possibility to amend the bill. I don't think that it could be amended to improve the situation as it currently is. As I say, you cannot improve upon no defence post-mortems as the situation currently is. A number of members have asked for further details around post-mortems, how they're conducted, the issue around recruitment of pathologists, and I of course will pass these matters on to the Lord Advocate, as we know, who has the responsibility as the head of the Crown and Procurator Fiscal Service in relation to matters regarding post-mortems, and ensure that responses are given to members. As I've said in the very beginning of my remarks, Presiding Officer, nobody should detract away from the hard work done by Bill Patterson on what is an incredibly sensitive issue, driven and motivated only to do good by victims and their families. He will be disappointed. I've spoken to Gil and he's expressed that disappointment to me. But what I can say is that we all, regardless of whether you support this bill or whether you will be opposing this bill at decision time, all of us, I hope it's understood, have only the victim's best interest at the forefront of our mind. Presiding Officer.
Thank you very much. I now call on Gil Patterson as the member in charge of the bill to wind up the debate. Mr. Patterson.
Presiding Officer, thanks very much for that. And I'll address some of the issues that have been raised throughout the debate. But it would be remiss of me not to thank all in the non-governmental bill unit of the Parliament for their sterling assistance over a long period of time with my bill, and also to all those agencies that I spoke to and met with who are directly involved in the delivery of the system of post-mortem in the justice system who also assisted me. The bill is a simple measure, but very significant, of very significant benefit for those families who lose loved ones in murder cases. I believe we can assist them in their desperate time of need by putting in place a time limit that begins as soon as the defence is in receipt, if people listen to this carefully, is in receipt of the findings from the first post-mortem report. That's in the bill, which is carried out on behalf of the Crown Office. The bill gives the defence 14 clear days to instruct the defence post-mortem. And this it allows this to be extended by the court multiple times, provided good reasons are given. It's very worthwhile noting that Scotland is unique in regards to post-mortem. I have researched, and no other legal jurisdiction that I've been able to find in any country in the world has a second automatic post-mortem on demand by the defence. Most do allow a second PM, but only after an application has been made to a judge or a coroner, providing good reasons. The Crown Office and the Cabinet Secretary for Justice has raised objections to the bill, but these, I would suggest to me, if they've got that wrong, they have clearly understood my bill. No evidence apart from mine has been presented to the Justice Committee, that's correct. For that reason alone, I urge the members to support my bill tonight, as this would allow the Justice Committee to indeed take further evidence and fully consider the concerns raised by the Crown Office. Some members have mentioned the Crown Office protocol. I welcome the protocol, it is good, but I don't think it's enough on its own. My bill does not alter or limit the protocol in any way. What it does do is complements the protocol and makes it more effective. That's the purpose of it. Without the bill, the defence can still delay deciding on a second post-mortem as long as they like, and there is absolutely nothing the protocol, the Crown Office, the courts or the government can do to force them to. Simply because a second post-mortem on demand without limitation is the law of Scotland. I don't want any appeal of that, a repeat of what happened in 2016 to families. A child of theirs had been brutally murdered, one a mere 15 years of age, and the families were caused further distress by the imperfections of our uncaring post-mortem system. I'm asking for the support tonight for my bill for the benefit of these families who face a similar tragedy in the future. Voting for the bill tonight will at the very least allow the Justice Committee to take the vital evidence, and I agree that's needed, included on the point raised by the Crown. That would allow the Parliament to take a fully informed decision whether or not to pass the bill when it reaches stage 3. Presiding Officer, there's only one ask of us by the families. It's to have their children back as soon as possible to help them grieve, and simply lay their children to rest. That's all.
Thank you very much, Mr. Park. Thank you very much. That concludes the debate on the post-mortem examinations defence time limit Scotland Bill, and it is now time to move on to the next item of business. And at this point, I will hand over to the presiding officer.
Thank you very much, Lewis MacDonald. And we're going to go to decision time. And there are two questions to be put this evening as a result of today's business. The first question is that motion 23946 in the name of Jean Freeman on the University of St Andrews Degrees in Medicine and Dentistry Bill at stage 1 be agreed. Now I'm going to ask members if they disagree, put an N in the chat box. So no need to indicate if you do agree, but if you disagree, put an N in the chat box on the Blue Jeans function. So are we all agreed? And there is no disagreement, therefore we are all agreed, and the University of St Andrews Bill is agreed at stage 1. Now the next question is that motion 23803 in the name of Gil Patterson on the post-mortem examinations defence time limit Scotland Bill at stage 1 be agreed. And again, I'm going to ask members if they disagree, put an N in the chat box. So no need to indicate if you agree, but put an N in the chat box. Are we all agreed? And I can see we're not agreed. Okay, so we're going to move to a vote. Now, to allow members to access the voting app, I'm going to have to suspend business for a few moments. So we're going to move to a short suspension. We will, just for members' information, we're going to switch off broadcasting, and I'll come back in and I'll give members the PIN number for the voting app. So a short suspension. Thank you, colleagues. Thank you, colleagues. We're now back, and we're going to go straight. Is that motion 2? I think we're frozen. Sorry, colleagues, I'm back again. I think I was. Okay, colleagues, I think that you're having difficulty hearing me, but you should be okay now. And I'm just saying that we are now back in session. So the final question today is that motion 23803 in the name of Gil Patterson on the post-mortem examinations defence time limit Scotland Bill at stage 1 be agreed. And members may cast their votes now. And for information, colleagues, this will be a 2-minute vote on Gil Patterson's bill. Thank you, colleagues. That vote is now closed. And I would encourage any member who wasn't able to vote to let me know through point of order, just in the chat box. Just flag it up in the chat box. Well, colleagues, there's a couple of points of order. We're just going to call them in a second, but any other member who has any difficulty voting, just let me know in the chat box. Gil Patterson, just to assure you, your vote was registered. You have voted. Okay, I'm going to call David Stewart for a point of order. David Stewart to make a point of order. Thanks, David. David, we can see you now, so if you want to make your point of order.
Thank you. I was having difficulties this evening voting. I would have voted yes.
Thank you very much. You would have voted yes, and that will be added to the voting register. Thanks very much, David. Thank you, colleagues. That vote is now closed, and I can confirm the result of the vote on motion 23803 in the name of Gil Patterson is yes 26, no 90. There was one abstention, and the motion is therefore not agreed. That was yes 26, no 90. There was one abstention, and the motion is not agreed. Now that concludes our business this evening. We'll be back in a hybrid meeting of Parliament tomorrow, but that concludes decision time, and I close this meeting.